Good morning, our members. It's 8:30. I just want to inquire from Gershwin. Gershwin, are we good to start?
Good morning, Chairperson and members. Yes, Chairperson, we have 7 members online.
Okay. Thank you very much. Welcome, honourable members, to this meeting. Just in terms of our proceedings today, while we're starting at 8, at 10 o'clock, we're expected to join the joint committee meeting with the Portfolio Committee on Home Affairs to deal with the Electoral Management Amendment Bill. So we will try and manage some of the items as we go along, especially in terms of time. But that being said, on members, just in terms of today's meeting, we will be getting a briefing by the Department of Police on the IPID Investigative, the IPID Amendment Bill. We will also deal with the Divorce Amendment Bill in terms of our consideration and/or the adoption of the committee report on this bill. And the final item we'll be dealing with is on the NPA Amendment Bill, as well as the submissions there too. Let me welcome you, members, and also I think in terms of the platform, we have the Deputy Minister of Police who's currently with us. I think the Deputy Minister for Justice will be joining us as we move along. We also have the Acting Secretary for the Civilian Secretariat for Police Services, Mr. Romaru. I see the Executive Director for IPID is also present on the platform. I understand that the NPA representatives from the NPA may also be on the platform as well. But let me welcome all of you, welcome the legal teams from the 2 departments, as well as from Parliament, who might be on the platform, other officials that are present. Honourable members, we did receive one apology from Honourable Badenhorst, and I take it that other members that are not here who did not send apologies will also be joining the meeting. That being said, honourable members, we'll then move on to the first agenda item, the briefing on the IPID Amendment Bill. Just to remind members that in the beginning of our term, we had made amendments to the IPID the IPID Bill, and that process, if members recall, I know there's about 5 members who are still in the committee that were part of that process. But that process commenced in 2016, which was immediately after a Constitutional Court judgment of McBride versus the Minister of Police and another in the McBride judgment. In this judgment, the Concord agreed with the applicant and declared Section 6 sub 3A and 6 sub 6 of the IPID Act invalid, to the extent that they authorized the Minister of Police to unilaterally take any disciplinary steps pursuant to suspension or remove from the office the Executive Director of IPID without parliamentary oversight, and Parliament was then given 24 months to rectify the constitutional defect. Sure, this defect was submitted to Parliament, and as a result, the IPID Amendment Act 2019 was signed into law by the President on the 26th of May 2020. And yeah, that's why all members will recall that this is one of the bills that were revived in the NCOP. This Amendment Act provided for parliamentary oversight in respect of the suspension, discipline, or removal of the Executive Director, as directed by the Concord in the McBride judgment. And after the enactment of the Amendment Act, the process of effecting comprehensive amendments to the Principal Act commenced, and a revised version of the bill, the IPID Amendment Bill 2023, was approved by Cabinet on the 24th of May 2023 for introduction in Parliament. The bill seeks to entrench the institutional and operational independence of IPID, as well as to make it expressly clear that IPID must be independent, impartial, or prejudice. I'm going to take this opportunity then to invite the Deputy Minister to start the process of taking the committee through on the IPID amendment bill. Thereafter, honourable members will be given an opportunity to engage with the presentation. Deputy Minister, over to yourself.
Thank you, Chairperson. Good morning to yourself. Good morning to members of the committee. It's an honor for us to appear before you on this amendment that are before the NCOP, having been passed by the National Assembly. We will interface with the processes of the committee to ensure that we provide the necessary support and information that committee members might require from the department. I am joined by the Executive Director of IPID, who I must upfront, I apologize to you, Chair, and members of the committee. She is in transit, but currently she is connected. She will have to board, and at that moment she will disconnect, but she will connect again once she lands. But the people who are relevant for the presentation of the amendment bill are present here, led by the Acting Secretary and Advocate Dawn Bell, and the team that she has been working with within the Civilian Secretariat and IPID. And indeed, Chair, this piece of legislation that you have before us addresses exactly the issues that you have raised, and we are quite confident that we should be able to find each other around this, and we will be guided by your good self. Without further ado, I will request through you that we allow the Acting Secretary, Mr. Ramaru, to lead in this regard, so that he also introduces the team that he is with, that will lead us in the presentation of the bill. I believe Advocate Bell will be leading this, but the Secretary will make that determination and indication of who in the team will lead the briefing to the committee. Thank you once more, Chair. And before I hand to him, I must also indicate that I have a doctor's appointment this morning at 11:30. I'll request to be allowed to disconnect so that I go and do the consultation. But the team will remain with members to proceed with the presentation. And if we finish early, I will come and reconnect and join the committee if the meeting will still be on by the time we conclude the consultations. But for now, I would like to request through you, Chair, that we allow the Acting Secretary to present, and to thank you once more for affording us an opportunity to interact with members of the NCOP on this important piece of legislation. Thanks very much, Chairperson. If you may allow, I'll request Mr. Ramaru to come in.
Thank you, DM. DM, I think we'll be done with your item long before the time you need to leave. Yeah, so obviously we would release the department at that point. But thank you, DM, for that. Over to you, Mr. Romero.
Good morning, Honorable Chairperson, Honorable Members, Honorable DM. Maybe I need to apologize that I'm experiencing challenges with my gadget, so that's why I'm connected through Advocate Bell's gadget. But as DM had indicated, I'm with the team, the drafting team led by Advocate Bell, and the team is constituted by staff from Civilian Secretariat and the Independent Police Investigative Directorate, IPID. So Advocate Bell will lead the presentation, and we will then answer questions if there are any through your directive, Chairperson. So through you, I will hand over to Advocate Bell to lead the presentation.
Good morning, Chair. Good morning, honorable members, honorable DM, Secretary, ED, colleagues, and all stakeholders on the platform. I'm now going to present to you the IPID Amendment Bill 2023. And if we go on to the purpose of this presentation, well, I'll provide the purpose, the background, the summary of the bill, and the recommendation. Next slide, please. And then the purpose, Chair, of this presentation to you is to request the Select Committee on Security and Justice to consider and support the bill. Next slide, please. Okay. Chair, just by way of background, this is a condensed snapshot of the processes followed by the department, which brings us to today's briefing on the IPID Amendment Bill. So the bill was introduced in Parliament on the 20th of July, 2023. Public submissions on the bill were conducted by the Portfolio Committee on Police on the 18th and 25th of October 2023. The Portfolio Committee on Police deliberations on the bill were conducted on the 1st, 8th, 10th, 15th, 18th, and 22nd of November 2023. These included, Chair, the public consultations and responses to the submissions. And then on the 29th of November 2023, the Portfolio Committee on Police adopted its report on the bill, and then on the 5th December 2023, the second reading debate on the bill took place, and the bill was passed by the National Assembly on the same day. Next slide, please. Chair, now we will be dealing with a summary of the bill. Clause 1 deals with definitions, and it seeks to amend Section 1 of the Principal Act through the insertion of certain new definitions. Chair, these are not included in the that were not previously included in the Principal Act, or they are as a result of amended clauses. For example, the definition on firearms, municipal manager, and executive head of the Municipal Police Service. Then Clause 2, Chair, deals with the establishment. It amends Section 3.2 of the Principal Act to provide that the Independent Police Investigative Directorate must exercise its functions in accordance with the Constitution. Next slide, please. Still on the summary of the bill, Clause 3 deals with independence and impartiality. The clause seeks to amend Section 4 of the Principal Act. It provides that the Directorate is institutionally and operationally independent and must exercise its powers and perform its functions independently and impartially without fear, favor, prejudice, or undue influence. Chair, this proposed amendment gives effect to the Constitutional Court judgment in the McBride versus the Minister of Police matter, and it aligns to the Act. It is important to note that a proposal was made in the previous public comments for amendment of the Constitution in order to fortify the independence and impartiality of IPID by elevating it to a Chapter 9 institution. Chair, the proposal was carefully considered However, it was decided that this matter requires consideration and a policy decision by Cabinet. Chair, IPID is a fully fledged government department. The Executive Director as its accounting officer. It also has its own budget appropriated by Parliament, and it is not dependent on any other department for its budget. Next slide, please. Clause 4. Next slide. May I continue, Chair? Okay, there I see it's there now. Clause 4, Chair, deals with the appointment of the Executive Director. Chair, this is in response to also concerns in the previous public comments regarding the lack of parliamentary oversight over the processes for appointment of the Executive Director. So Section 6 of the Principal Act has been substituted. The result being that Clause 6(1)(a) now provides for appointment of a panel to assist the Minister with the nomination of a candidate for the Executive Director post and the submission of the name of the candidate to the relevant parliamentary committee for approval. This is found in Clause 6(1)(b). This, Chair, has been the practice over the years. The Minister has a panel which assists him with the shortlisting, interviews, nomination, and recommendation to the Parliamentary Committee for confirmation or rejection of the candidate. Chair, it must also be noted that there was very rigorous debate and discussion on this particular clause. So the remainder of the subsections of Section 6 of the Principal Act have been strengthened. For example, Chair, the appointment of the non-renewable period of 7 years provides certainty with no ambiguity. The criteria and characteristics that are required are now spelled out, and how the remuneration and allowances and other terms of conditions must be dealt with. And these are all in terms of the Executive Director. Chair, there was also a proposal that the remuneration of the Executive Director should be set at a statutory minimum. That proposal, Chair, was not accepted because there are administrative processes that deal with such issues outside of an act. It is emphasized that IPID is a government department and not a Chapter 9 institution. Can we go to the next slide, please? Okay, sorry, Chair, just before we get to the next slide, I just want to also expand on this clause 4 because of the amount and the depth of discussion that went into it, just for an understanding and a background. The Executive Director, Chair, falls under the predetermined public service salary structure. So between the two ministers, that is our minister, the Minister of Police, and the Minister responsible for finance, consensus can determine the notch within the salary structure. Therefore, there is no deviation. Any deviation in terms of lowering the salary will attract legal ramifications. Then, Chair, lastly, the clause 6(5)(a), B, and C makes provision for the time frame for the replacement period in the event of a vacancy. Chair, as a government department, IPID reports to the Minister of Police, and therefore he or she has the authority and responsibility to ensure that IPID operates uninterrupted by a vacancy, which is usually filled by a chief director within the directorate and not an outsider. And this will be done with the concurrence of the relevant parliamentary committee. Chair, the time frame in the Principal Act allows for a period to not exceed 1 year. This has been substituted to allow that the vacant position must be filled within 6 months. And this, Chair, is considered reasonable given all the administrative processes that have to be followed. Now I will go on to clause 5. So clause 5 deals with the responsibilities of the Executive Director, and it seeks to amend Section 7 of the Principal Act in order to ensure that the recommendations, and Chair, this word recommendations replaces the previous one that was used, that was complaints. The recommendations regarding disciplinary matters that involve certain provincial and national executives that are referred to in that these matters are referred to the appropriate authorities, including the municipal manager and the executive head of the Municipal Police Service. Chair, this amendment is a result of a proposal in the previous public comments that reference should be made to recommendations in order to align provisions in the Act with the disciplinary recommendations in Section 30 of the Principal Act. The clause has been further amended to provide that the initiation of an investigation by the Executive Director upon becoming aware of a complaint against a member of SAPS or the MPS, and not only upon receipt of a complaint. Chair, this will also ensure that the investigations are dealt with expeditiously. Next slide, please. Chair, we move on to clause 6, which deals with the composition of the National Office. And this clause provides for the deletion of Section 8.1 in the Principal Act, which makes provision for the composition of the National Office of the Directorate. Chair, this is a matter that is better dealt with through IPA's internal policies and processes rather than to be placed in an amendment act. The clause further amends how and by whom pre-employment security screening investigation should be conducted, and that is by the Directorate and not by the State Security Agency as provided in the Principal Act. Chair, for the sake of clarity, the security screening deals with criminal and credit checks and the authenticity of qualifications, and these can be conducted internally by IPID. Once the person has been appointed chair, he or she must be issued with a certificate, and this, Chair, after a vetting investigation has been carried out in terms of the Intelligence Services Act 2002, which is a much more detailed and rigorous procedure conducted by the State Security Agency. So there's a difference here, Chair, between the security screening and the vetting that gets done. So I hope that this has been explained. Next slide, please. Chair, we move on. It amends Section 9 of the Principal Act, which provides for the identification and the review of legislative needs in consultation with the Secretariat, that being ourselves, the CSPS, and the reporting on such matters is to be made to the Minister and not to the Secretariat as provided for in the Principal Act. And just for clarity's sake, the Civilian Secretariat for Police Service is responsible for drafting legislation in the police portfolio, done in consultation with the department concerned. And just as a recent example, Chair, the CSPS, together with the relevant members of SAPS, recently brought before this very committee 2 bills which have been promulgated into law around December 2022, and this is the DNA Act, the DNA Amendment Act, and the POCTATARA. These acts are both implemented by SAPS. Clause 8, Chair, deals with delegations. It amends Section 3 of subsection 3 of Section 10 in the Principal Act through delegation of reference to Section 7 sub 9, which in order to empower the Executive Director to delegate the initiation of investigations of any offence allegedly committed by any member of the SAPS or the MPS, and to the relevant provincial head of the Directorate. Next slide, please. Clause 9, Chair, deals with the composition of the forum, which seeks to amend Section 19 of the Principal Act through providing that a person, a representative from a government department or an institution may be invited to a meeting of the forum if a particular matter concerns such person, government department or institution. And just as an explanation, Chair, this means that where there are questions around certain issues pertaining, for example, either the NPA or SAPS, which negatively impact on certain functions of IPID, the relevant officials from the NPA or SAPS, as the case may be, will be invited to attend a meeting of this forum. So this is not to be prescriptive in an act concerning other entities, institutions, or departments. Clause 10 deals with the provincial offices, and this clause repeals Section 19 of the Principal Act, which sets out the salary levels of provincial heads of the Directorate. Chair, it's considered not necessary to provide such matters in the Amendment Act. Next slide, please. Clause 11, Chair, deals with the responsibilities of the provincial heads, and it provides for the deletion of paragraph M of subsection 1 of section 21 of the Principal Act, which provides for the preparation of financial statements by the provincial heads of IPID. This, in practice, Chair, is that these statements are prepared only by the national office, so this section has been deleted. Clause 12, Chair, deals with the appointment of investigators. Chair, Section 22 has been amended in order to address the concern in the previous comments that the deletion of qualification requirements of IPID investigators will have the effect of juniorizing the level of entry for investigators, which is considered to be the backbone of IPID. Therefore, the proposal is that a person who is appointed as an investigator must at least have a grade 12 certificate or equivalent and a relevant diploma or degree. The investigators have separate remuneration dispensation to other officials in IPID, and therefore they will need to be better qualified and skilled. The next slide, please. Chair, the clause also provides for the conducting of pre-employment security screening of investigators by the Directorate, and this, as previously mentioned, which affects other employees of the Directorate, would also involve credit checks, criminal records, and authentication of qualifications. The same process for the security clearance certificate is followed, as mentioned in slide 10. That is where we differentiate between the security screening and the vetting that must happen within the department. So then clause 13 deals with the remuneration and conditions of service of investigators. It seeks to amend section 23 of the Principal Act. It provides that the conditions of service, including salary and allowances payable to investigators, shall be determined by the Minister in consultation with the Minister responsible for finance. Chair, a concern was also raised in the previous public comments that this proposed amendment creates a serious precedent for salaries of certain officials to be determined by ministerial decree, whilst the majority of public servants enjoy the right to have conditions of service and determined through the recognized collective bargaining structures within the public service. Next slide, please. Okay, so this concern was considered. However, it was not accepted as IPID investigators are appointed in terms of the Principal Act and not the Public Service Act, and therefore have a different compensation dispensation. They are also members of labor unions who would ensure that their labor relations matters are catered for. Furthermore, there is a special unit within the General Public Service Sectoral Bargaining Council that deals with investigators labor issues. Clause 14, Chair, deals with the functions and investigative powers. It provides for the insertion of paragraph B capital A in subsection 2 of section 24 of the Principal Act. In order to bestow upon IPID investigators the power to take buccal samples in terms of the South African Police Service Act 68 of 1995. This will also fall under the DNA Act, Chair. Chair, further amendments to address the concerns that were raised in the previous comments relating to the fact that the bill provides for inadmissibility in criminal proceedings of self-incriminating answers, as this nullifies the purpose of other proposed amendments to section 24, as a person questioned is free not to answer self-incriminating questions, and to add, the purpose arising out of public comments to amend Section 24(5) along the lines of the NPA Act, this cannot be considered, Chair, because the questioning by IPID investigators differs from the NPA in that the NPA's questions relate to criminal proceedings, whereas those of IPID are for purposes of conducting investigations. Next slide, please. The clause further provides for insertion of paragraphs 6, 7, 8, 9, 10, and 11 of the section of the Act in order to strengthen the provisions relating to investigative powers of IPID investigators, such as by empowering them to subpoena witnesses to appear before them for the purpose of giving evidence under oath. The consequences for failure to comply or cooperate with IPID investigators are provided for in sections 4 sub 2, section 29 sub 2, and section 33 sub 3. Limitation proposes an insertion of section 2, subsection 2 in section 27 of the Principal Act, which provides for limitation of liability of officials of the Directorate. Chair, this amendment is in line with other legislation, for example, section 5(3) of the Public Protector Act. Clause 16 deals with types of matters to be investigated. Chair, this was also a very hotly contested and debated section or clause, and it seeks to amend subsection 1 of section 28 of the Principal Act in order to provide that the Directorate shall investigate the crimes of rape and murder, whether they have been committed on or off duty. Chair, these provisions are also provoked very robust debate and discussion, as I mentioned a moment ago. If we can move on to the next slide, please. Chair, in paragraph B, Regulation 4(1), it provides for the investigation of death of a person in public, in police custody, or the death as a result of police action or omission. Regulation 4(1) provides the investigation of death by a person in police custody or death as a result of a police action or omission, or both. So this is just to emphasize that it doesn't only deal with police action, but it also refers to the omission of any action that should have been carried out by a member of the police or the MPS. In paragraph C, Chair, the complaint of a discharge of an official firearm by any police officer is repealed. The amendments to paragraph F provides that IPID shall investigate the allegations of assault only if it is committed with the intention to cause grievous bodily harm. Chair, again, cognizance was also had over the concerns that were raised in the previous public comments regarding the deletion of a provision on investigation of complaints of assault. The proposal was made to retain the investigation of assault complaints by IPID as not only is assault an abuse of power, but the distinction between common assault and assault with intent to cause grievous bodily harm is often subjective and only based on visible injury. So, Chair, the proposal was not accepted as most common assault cases arise where there has been resistance during the arrest, and in some cases it is clear that there is no evidence of physical assault, as such making it difficult for IPID to pursue such case, as well as taking the focus of its resources, and therefore the focus is mainly on assault GBH cases. Next slide, please. Okay. Chair, it is also prudent to note that common assault is not automatically precluded as a recourse it can be had in terms of section 7 sub 9 of the Act, and in terms of the standing operation procedures. IPID conducts screenings of assault matters to determine which ones require further investigation and are not as a result of minimum force used to effect arrest. This is further strengthened by the information that is contained on the J88 form. Then we move on to paragraph G, sub G, which provides for the referral of corruption matters by the National Commissioner or the appropriate provincial commissioner, the national head or appropriate provincial head of the Directorate of Priority Crime Investigation, the executive head of the relevant municipal service, and the municipal manager. Attempted murder in relation to discharge of an official firearm has been inserted as a new paragraph G, capital A. The paragraph has been further amended in order to take into account of the proposal in the previous public comments that attempted murder should not be limited to the use of firearms only. And as a result, the wording through the use of any weapon or instrument has been inserted in paragraph GA. As explanation, Chair, the paragraph has been further amended in order to take into account of a proposal in the previous public comments that attempted murder should not be limited to the use of firearms only. And as a result, the wording through the use of any weapon or instrument has been included. It must also be emphasized that IPID's mandate in terms of Section 206 over the SAPS and MPS and not any other law enforcement agency. Next slide, please. Next slide, please. Chair, in the interest of time, if I may proceed. Clause 17, okay, there it is now. Report deals with the reporting obligation by members. It amends the amendments proposed to Section 29 of the Principal Act impose the reporting obligations in relation to matters for investigation by IPID in terms of Section 28. Included are the municipal manager and the executive head of the municipal police service, or any. Clause 18 deals with disciplinary recommendations, and it seeks to amend Section 30 of the Principal Act in order to strengthen the provisions relating to the implementation of disciplinary recommendations of IPID, as well as to specify whether the disciplinary recommendations of the Directorate were implemented and the extent of the implementation thereof. In the published version of the bill, it was provided that the SAPS or the MPS initiate discipline after the investigation of allegations has been finalized by the Directorate and upon receipt of the investigation report. Chair, it must be emphasized that IPID's mandate in terms of, okay, this is a repetition, but it has been, just to reinforce that Section 2 of the Constitution only allows for MPS and SAPS and not other agencies. Okay, going to continue. I'll continue then. A comment was raised in the previous comments, public comments, was that this proposed amendment is undesirable. It has the potential to do great harm by curtailing police management from initiating disciplinary steps or precautionary measures against police officers with prima facie evidence of egregious criminality against them, enabling such officers to remain on duty pending the outcome of an IPID investigation. The proposal that is in its place in the bill is that the bill should provide a clause allowing IPID executive to request SAPS or MPS to suspend disciplinary steps pending the outcome of the IPID investigation in specific cases where the particular circumstance of the case arguably warrants suspension. Therefore, the word must was replaced with may in order to afford exercise a discretion discretion whether or not to suspend the initiation of disciplinary proceedings. Next slide, please. Okay, just before I go on to that, Chair, I just want to further explain that provision has been made proceedings to be a parallel delays in the outcome. Therefore, the word must was replaced with may in order to afford SAPS and MPS management an opportunity to exercise discretion as to whether or not disciplinary proceedings. Chair, there are also sufficient checks and balances to ensure that SAPS is indeed following the recommendation of IPID, such as reporting to the Minister, the Portfolio Committee on Police, and the Civilian Secretariat for Police Service, who can inquire on any irregularity with SAPS's outcome of discipline, process, and sanction. It must also be noted that IPID's recommendations are remedial in nature and not binding. And this is the same with the public protector, whose findings are not binding and may in some cases require definite rulings by the court. So I'll move on now to, in order to address the proposal in the previous public comments that there should be clear consequences for failure to act on recommendations to ensure the accountability of some new subsection has been inserted, providing considered the Directorate may request appropriate authorities of SAPS and MPS to review such sanction. Clause 19, Chair, deals with finances and accountability, and it seeks to amend Section 31 to provide that IPID shall be accountable to Parliament and not only the Minister as stated in the Principal Act. Clause 20 deals with offences and penalties, and in order to address the above-mentioned proposal of the for failure to actions of the Directorate to ensure accountability, Section 33 of the Principal Act has been amended to provide that if appropriate authorities of MPS and SAPS fail to comply with Sections 29 and 30, they shall be guilty of an offence and liable to a fine, next slide please, or imprisonment for a period not exceeding 2 years. Chair, it is common cause that the sanction is in the hands of the court as is the amount of the fine. This too is within the purview of the court, who is guided by the Adjustment of Fines Act, and therefore the exact sanction of imprisonment or the amount of fine cannot be expressed in legislation other than that which I have stated above, that is the Adjustment of Fines Act. Clause 21 deals with regulations, and it amends Section 34 of the Principal Act in order to empower the Minister to make regulations in relation to certain matters, procedure to be followed in appointing investigators. The new insertion strengthens the Principal Act. The new insertions, sorry, plural. Clause 22 deals with the savings clause, and it provides for substitution of Section 35 of the Principal Act as the transitional arrangements provided therein have been fully implemented. The saving clause, Chair, will ensure that the conditions of service, including the remuneration and benefits payable to the employees of IPID before the next slide, please, the commencement of these amendments to the principal to the amendments of the Principal Act may not be less favorable upon the comment of this Act. Clause 23, Chair, deals with the arrangement of these sections, and it provides for the substitution of headings of certain sections of the Act. Clause 24 deals with the short title and commencement, and it provides for the determination of the date on which the Act will come into Parliament Gazette. Then the next slide, Chair, deals with the recommendation, and it is humbly recommended that the Select Committee on Security and Justice considers and supports this bill. I thank you, Chair.
Thank you very much, Ms. Bell, Mr. Romaro, the GM, for the presentation, and Ms. Bell for the additional information with reference to discussions that have been taken on the bill, especially in turn by the Portfolio Committee. That being said, honourable members, at this point, are there any members that would like to ask any questions, clarity on the presentation and or comment? Our members? Okay, I'm not seeing any hand at the moment. Okay, I think perhaps also, okay, I see Honorable Maleka and Honorable Dudogo. Perhaps Honorable Maleka.
Thank you, Chairperson.
Honorable Maleka.
Yes, did you hear me, Chairperson?
Yes, we can hear you. Please continue, Honorable Maleka.
Oh, okay. Chairperson, greeting the department and honorable members. Did you hear me, Chairperson?
Yes, we can hear you. Please continue.
I want to check there on clause 4, which deals with the appointment of the executive director. The reference is made to the appointment of a panel. Can the department explain more on this and who will serve on such a panel? And also clarify the use of pre-employment security screening, which is reflected in the bill in clause 6 and 12, that the Directorate have the necessary capacity to conduct such screening processes. Thank you, Chairperson.
Thank you very much, Honorable Maleka. Honorable Dudogo.
Thank you very much, Honorable Chair. I really apologize. I'm not going to show my face. I have a network problems as a result of load shedding here. Firstly, Chair, I want to welcome the presentation. I think it was very, very good. And thank the Deputy Minister. He's always upfront, he's always there to engage with the committee, and I really wish him speedy recovery as he goes to see the doctor. Secondly, Chair, some few questions. As I understand the presentation, this bill was order of the Concord, which gave Parliament 2 years to rectify the invalidity that it identified. I'll tell you what is my concern, and it is a concern that I expressed last week in one of our meetings, that this comes very late to us as the NCOP. This bill, as I understand, it was only passed by the National Assembly on the 5th of December, and at that time, we were going on a recess, and we only came back last week. And now this puts a lot of pressure to us as the NCOP to really do our ensure that we ensure public participation, effective and meaningful public participation, and as such, as a committee, to properly deliberate on that. And this is a concern that I will continue to raise, because it puts us under unnecessary pressure, in which we don't rationalize our time, and as such, we give little time to the NCOP to reflect on important legislation such as this one. Fourthly, Chair, I heard the presenter saying, and I agree with her, this is the IP is not a section, it's not a Chapter 9 institution. And in a presentation, she indicated that this requires a policy decision. Maybe if I take the advantage of the fact that the Deputy Minister is here, he can brief us and take us into confidence with regard to that particular process. I'm saying this because ideally, in my respective view, IPID should be a chapter 9 institution to guarantee its independence, because it's a very, very important institution. And obviously, if that is the case, that will require a constitutional amendment to ensure that we incorporate this as part of the chapter 9 institution. Now, my question would be, is there any process that has been mooted, that has been started to ensure the realization of this? Because in my respective view, if it is a chapter 9 institution, it will promote and protect democracy like all other institutions, but equally important, it will address all the issues that were highlighted by the Concord, as it were. And this is my view, and I want to really understand what processes, if any, that the government or the cabinet has taken in respect of this particular matter. Thank you very much, Honorable Chair.
Thank you very much, honorable members, for raising those issues. Honorable Mikalakis, I see your hand came up now. I didn't note it earlier. Honorable Mikalakis?
Thank you very much, Chair. Good morning, everyone. Chairperson, I just have two comments. The first one is to echo the sentiment of Honourable Dudorvo, and just to express my wishes that he takes those sentiments into the programming meeting as well. The NCOP is under a lot of pressure to deal with legislation, and we can't deal with all of them properly the way things are going currently. I've raised this 3-4 times with regards to various legislation, and I'm glad that the honourable member and hopefully all of the members on the committee is on board with that finally, that we cannot be expected to deal with legislation in a rushed way, regardless of any deadlines, which I don't think we have in this case. But certainly it is becoming silly season at the end of a parliamentary term, and we should guard against that to make sure that we process legislation properly. The second comment I want to make, Chairperson, is that the problem with IPID, as we all know, is not the legislation. Our legislation is usually of a good quality. It comes with the implementation. And in that sense, it's more comment to the Deputy Minister that should he be in the unlikely but fortunate situation where his party is in charge of the budget after the elections again, that it will depend, the effectiveness of this legislation will depend on whether they finally can fund IPID properly, because IPID has been, as we know, grossly underfunded up to now, and for that reason, it cannot fulfill its constitutional mandate. Thank you.
Thank you very much, honourable members, for those questions and comments. Let me hand over to yourself, Deputy Minister, to deal with the responses.
No, thanks, Chair, and thanks, members, for the comments and the questions. And indeed, the issues of the legislations that we have suffices for us to carry out our responsibilities, but from time to time, it's necessary that we make amendment to be in line with the tests that they get subjected to from time to time. Like in this case, lawmakers passed a law which in their own wisdom they thought is a good piece of legislation. But as it gets implemented, it gets tested in the course of work. It was found that there is a need to make the amendment, hence we are making the amendments now. And in our own wisdom, we were confident that we are doing the right thing we will adopt this piece of legislation, but in the course of execution, something else which we did not foresee now might arise, which will then necessitate us to amend the same piece of legislation that we are amending today. I'm just saying us in the context of us being lawmakers. Like I have said, we have made legislations before. There were amendments which were made, but not by ourselves, but by those who came before us. In their wisdom, they did what is right. But here we are making further amendments. And as we implement this amendment that we are making, it might arise that there is a need for a section to be further tweaked to make it more good. The lawmakers then will do that. As things stand, the Constitution of the Republic defines Chapter 9 institutions and what they are meant for. And we have not reached a determination that those Chapter 9 institutions are not sufficient. We think they are sufficient and there is no need to go in that direction. I think the comment that Advocate Bell made in this context is because there were South Africans who were of the view that perhaps we should make it a Chapter 9 institution. I will argue that it's not necessary. That question does not arise. In fact, IPID is one institution that have been created by the democratic dispensation that has got a potential of withering away, if I were to borrow Marx's analysis around the state. It will wither away in the sense that the moment it becomes effective and very efficient and contribute towards the professionalization of the conduct of the South African Police Service members, there will be no need for an IPAD because police will have internalized the Constitution of the Republic. They will have internalized all other principles and values that will be reflective of a conduct of a great citizen of this country, and police officers being these citizens. They will be conducting themselves beyond reproach in a manner that it is not necessary to have a watchdog to watch over them. At that moment, it won't be necessary for IPAD to exist. Therefore, if an institution like that, you turn it into a Chapter 9 institution, having to even amend the Constitution to factor it in, I don't think it will be appropriate for us to go into that direction, because it is basically there because of our past and the conduct of some of our police officers, which is still a problem today, because we have elements in the police who conduct themselves in a manner that it's not in keeping with the law. That's why they do things that they are not supposed to do. And as a result, you want somebody to police over them. And that's where IPAD comes in. And my own view is and attitude is that IPAD is an instrument that, together with the other instruments that we have put in place, will contribute towards, they act as a deterrent for police officers to conduct themselves appropriately. And in the process, like I said, together with other instruments, we are continuously training our police officers to conduct themselves in a manner that is in keeping with policing in a democratic South Africa, which is guided and governed by the Constitution of the Republic, which is the supreme law of the land, within which we have got a section on human rights. And once we have police officers that understand that and conduct themselves accordingly, this ceases to be relevant. And therefore, I will argue that we shouldn't go into that direction. But as lawmakers, you have the right to amend the Constitution. Is within your powers to start a process that will ultimately lead to the amendment of the Constitution. And if lawmakers in their own wisdom feel that this must become a Chapter 9 institution, so it will be. But I will advise that we should not go that direction. The issues of course, I agree with Honorable Mikalakis that with this legislation in particular, it is not, there is no pressure around it. You will be able to process it within the times that you have been afforded. But I fully share the concerns that he has raised, which were raised by Honorable Dodovo, that we should, as far as possible, avoid situations where in the NCOP is bombarded with legislation that makes it difficult for it to do its responsibility appropriately and in a manner that they have enough space to do so. I'm commenting along these lines because I know that there is a piece of legislation, I think it was the Pokrata Act, which we had to bring on the 11th hour before you, and we did apologize to yourselves that we really should not have done that, but we did it, and we had to push you to process it within very short time frames, and you were able to do that, and we would like to commend you once more, Chairperson and members of the committee, for have considered the country first and did what you could to make your contribution, which you did excellently well. We commend you for that, but we sympathize with the sentiment as reflected. But I will allow Advocate Bell to talk to the issue that was raised earlier on and any other matter that I might not have addressed. Thank you, Chairperson, for the opportunity. Thank you.
Thanks, Deputy Minister. Chairperson. I will actually deal with them instead of Advocate Bell. It's two issues that the Deputy Minister didn't deal with. The first one has to do with the appointment panel. So, Chairperson, there are legal frameworks that the appointment of heads of departments or heads of institutions in government follow. And these are clearly outlined in number 1, Executive Protocol of 2020, the Public Service Regulations, and also the Public Service Act. So, but to be brief in terms of the composition of the panel, so they indicate that the executive authority responsible for that environment is the chairperson of the panel, and there must be 2 other ministers who are appointed into the panel, and it also makes provision that there must be a director general from a national department who forms part of the panel. So that is how the composition of the panel is done. So it's regulated. It's not what the executive authority or minister just decides on its own. Then the second question is with regard to whether IPID will have capacity to deal with pre-employment screening. Chairperson, I need to indicate that this is a function that IPID is already performing and all other government departments are performing. So when we talk about pre-employment screening, we're basically referring to a basic HR function where they've got to verify the criminal record of the candidate, the credit record, and also the qualifications which they do through, I think it's SAC. And so that's basically what they do. So once that is done and confirmed, then the person is appointed. But there is always a clause in the contract that says this employment will be subject to successful vetting. And when we talk about vetting now, that's where a rigorous process is undertaken, and that is done only by the state security. So those were the two questions that the DM didn't respond to. Thanks, Chairperson.
Thank you very much, Mr. Ramaro and Deputy Minister for all of those responses. Maybe also to indicate that the bill, while it was referred to the committee in the previous term, I don't have the date of hand, but it was also advertised for public comment from the 8th of December to the 19th of January. Our members, we will continue interacting and engaging the department on this bill in the next meeting, where we will also expect the department to provide us with the responses to the public comments. And TM, if we can get those responses early so that members can also familiarize themselves with those responses. And then our members, we will, in our next meeting, continue with the processing of this bill. Let me take this opportunity, DM, to thank you, to thank the Civilian Secretariat for Police Services, as well as the IPID Executive Director, who I think was on the platform, or still is, for your questions to the committee. DM, let me also then release you and your team for now, so that as a committee we can continue with the business of the morning. Thank you very much, and your team.
Thank you very much, Chairperson. Thank you, members.
Our members, I know time is a bit against us in terms of what we had intended to do today, but also the agenda was not necessarily revised, given that we had to move our meeting earlier and also shorten it by half the time, rather. But I think the DM, I know you are on the platform. I'm not sure if the National Director is also your DM, but I'm going to just welcome you once again to this forum. Just in terms of the agenda items that are remaining, it's in relation to the Divorce Amendment Bill, and then we had also expected a briefing on the NPA Amendment Bill, which I think, given the time and the fact that members need to get into a joint meeting with the Portfolio Home Affairs by 10. DM, I must just apologize profusely, because I don't think we'll be able to deal with the NPA at this point, but we will schedule it for the next meeting of the committee, and my apologies for that. Our members, we'll then move into the next item, which is the consideration and adoption of the Divorce Amendment Bill. Our members, in our last meeting on this bill, which was held on the 25th of January 2024, the department responded to submissions on the bill, and in particular, the department spent quite some time explaining the rationale in respect of the retrospective application in the bill. The department was clear that the bill addresses the Constitutional Court judgment in Women's Legal Center Trust versus President of the Republic of South Africa and others, and that the remaining matters will be addressed in the Marriage Bill of the Department of Home Affairs. To this end, the department also provided a detailed research note an explanation on retrospectivity in the last meeting of the committee. In addition, in that meeting, the parliamentary legal advisor also clarified the tagging of the bill as a Section 75 bill, as well as the extensive public participation process this bill had gone through. I'm going to invite honourable members if you have any additional comments on the bill. If you can give me an indication, but if you are happy with the deliberations and the information that was provided, if you would then allow me to move for the adoption of the bill. Okay, I'm not seeing any hands on members, so if there is no further deliberation on the bill. Okay, I would table the bill without any amendments. I see Honourable Bartlett is moving for the adoption of the bill without any amendments. Is there any seconder? Honourable members?
Ndungeni, Chair. Seconded.
Thank you very much, Honourable Ndungeni. Are there any objections and or abstentions? Any objections and or abstentions? Okay, if there are none, thank you very much, honourable members. The bill without the divorce amendment bill without amendments is hereby adopted. And members, then we've also provided you with a draft report on the bill, and I'm going to request Gershwin to take us through the report.
Chairperson, thank you. Before we proceed, Chair, I see there's a hand that's up.
Okay, but it's Honourable Hendricks, you're from another House of Parliament, so at this point, I think we would not allow you to speak. Gershwin, please continue.
Thank you, Chairperson and members. If you forgive me, I'm having load shedding as well, so I'm going to keep the video off. Members, we are presenting the report on the Select Committee on the Divorce Amendment Bill, and the Select Committee, having deliberated on and considered the subject of the Divorce Amendment Bill, Bill 22-2023, National Assembly, Section 75, referred to it on 15 November 2023, reports that it has agreed to the bill without proposed amendments. Chairperson, in the background, the bill seeks to amend the Divorce Act 1979 to insert the definition for a Muslim marriage, provide for the protection to safeguard the interests of dependent and minor children of a Muslim marriage, provide for the redistribution of assets on the dissolution of a Muslim marriage, provide for the forfeiture of patrimonial benefits of a Muslim marriage, and to provide for matters connected therewith. Chairperson, we invited stakeholders and interested persons to make written submissions and publish the adverts in all official languages in Parliament's electronic platforms from 15 November to 5 December. We received 5 submissions, Chairperson, and the Annexure A will contain the department's response to those submissions, Chair. Then moving on to the consideration, we received a briefing on the bill on 15 November 2023. On 25 January, the Select Committee received a briefing from the department on the public submissions received for the bill. And today, Chairperson, the committee has adopted the bill without proposed amendments. Chairperson, I'm going to leave the recommendation up to you. Just to read it quickly, the committee, having considered the Divorce Amendment Bill, referred to it on 15 November 2023 and classified by the JTM in Section 75 Bill, recommends the Council pass the bill without proposed amendments. Thank you, Chair.
Thank you very much, Gershwin, for also dealing with the recommendation. As stated, honourable members, that the committee having considered the Divorce Amendment Bill B22/2023, we recommend the council pass the bill without proposed amendments. Is there any addition that any honourable member would want to make to the report? I see iPhone 3. Is that you, Honourable Motsamai?
Yeah, thanks, Chair. It's me. I was just want to move, Chair, for the report.
Honourable Motsamai, okay. I'll note that if there's no addition that honourable members want to make, then members will move into the next stage for the adoption of the report. Honourable Motsamai has moved for the adoption of the report. Is there any seconder?
I second, Honourable Chair.
Thank you very much, Honourable Bartlett, for seconding the report. Thank you, honourable members. The report is adopted, and I think this bill will go a long way in providing recognition of the protection for Muslim women and children of Muslim marriages on the dissolution of a Muslim marriage. And obviously, it gives effect to the Concord judgment. That being said, honourable members, I'm going to then end the meeting given that we will deal with the NPA amendment bill and the submissions, public submissions we received on that bill in a subsequent meeting. And it will also give members time to then also log on to the joint meeting with the Portfolio Committee on Home Affairs, which is scheduled to start at 10. Once again, DM, my apologies to you and to the NPA for not having the time to deal with the item as we had scheduled. But I know you'd understand that we have another meeting to deal with. But also, I should just indicate that the joint meeting with Home Affairs was not scheduled for today. It had just come up because of other problems with some of the documentation that was needed in that meeting. But be that as it may, I know that we're all aware that we need to deal with the Electoral Matters Amendment Bill can be held, in due course. Thank you very much, honourable members, for your attendance and participation, and thank you to the DM Justice for attendance. Thank you very much, honourable members. This meeting is adjourned.
Thank you.
Thank you, Chair.
Thank you, Chair. Mola Mutsamai.
Thank you.